for the record, so the record complete. Take a scene view this morning to the jury out the location of the alleged crime scene. So you can view of the crime scene starting not at 9 o'clock this morning, but later than 9 o'clock. The jurors all present now return from that location. Are those sounds ready to proceed at this point?
Yes, sir.
You said you have an additional proof that you anticipate presenting.
No.
Expect. Yes, sir. You bring in jury, please, sir.
Yes, sir.
For the record, also, Mr. Wilbourn is present at this point, standing as not present in the courtroom. Yes, sir. Good morning. Thank you, everyone. Everyone can see. Ladies and gentlemen, good morning. How are your accommodations? How are the meals?
Excellent.
Deputies get better.
Yes, sir.
I want to tell you, if you have any questions from the scene view, if you have any questions, put them in writing. If someone has any questions after viewing the location of the alleged crime. Ladies and gentlemen, when we stopped yesterday, I told you the state of Tennessee might have additional proof. I also told you that the state might have concluded their proof against Mr. Wilbourn. Mr. Anderson of this Bird, the state have an additional proof at this time to submit?
No, Your Honor. At this time, Your Honor, ladies and gentlemen of the jury, the state rests its case.
Ladies and gentlemen, the state of Tennessee has rested its case against Mr. Wilbourn. Mr. Gangula, Ms. Paul, Ms. Pastor, and Mr. Wilbourn will be given an opportunity to submit additional proof if they choose to do so. What I've been telling you now for 5 days, 6 days, is that Mr. Gangula, Ms. Wilbourn, Ms. Hall, Ms. Ashley do not have to present an additional proof. I need to discuss that out of your presence because the law requires me to have a discussion without your being present as to whether or not Mr. Wilbourn chooses to present additional proof. If he does, you hear that in a few minutes. If he chooses not to, you would have heard all the proof that you hear in this case. You cannot discuss the case with anyone. You cannot discuss the case amongst yourselves. I hate to send you right back to the jury room when you just came back into the courtroom, but legally I have to have this discussion outside of your presence. So if you follow the deputy slip back to the jury room, we'll see you back in a few minutes. Thank you. Gang Bill, the state of Tennessee, have arrested this case against Mr. Wilbourn. Do you have any motions that you want to present at this time?
Yes, sir. Thank you.
Yes, sir.
Pursuant to Rules 29 and 33 of the Criminal Procedure, we are asking for the motion of judgment of acquittal to believe that no rational prior fact could convict Mr. Wilbourn of first degree murder based on these facts. We do realize that pursuant to prevailing case law, the court has not to view the evidence in the light most favorable to the state of Tennessee. But with that said, again, no rational prior fact to convict Mr. Wilbourn of first degree murder based on these facts because there is still no evidence of premeditation. All the witnesses are testifying that Mr. Wilbourn pulled Mr. Wilbourn out of the car. Mr. Wilbourn made some statements, and immediately after that, Mr. Wilbourn got. We believe that there is no evidence of premeditation. I would ask the court to grant our motion.
Mr. Anderson.
Judge, as the defense counsel said, obviously the court does under prevailing case law view this motion in light of favor to the state. I think the proof does show more than one witness that there is grounds for the jury, in fact, the jury to consider for first degree murder, including Wilbourn and little Dave were nearly sitting in the car. Police officer Sean Bolton came up, shined the spotlight. So Lanier left. Mr. Wilbourn remained. Mr. Wilbourn got out of the car. Mr. Wilbourn, knowing he had a weapon on him in the car with him, pulled that weapon out. There's the testimony that he pushed the officer back and began to shoot him. And in fact, the proof has shown that after he shot him, he continued to shoot him even after he was down, shot 11 times, including 8 times when the officer was struck, pursuant to the testimony of the medical examiner. Based on all that information, Judge, and of course the court knows that as long as there's time for reflection and judgment, there is no definitive time for premeditation. And under those facts, I believe that trial of fact, the jury in this case, certainly can make that determination. And these are not, this is not a matter of law. These are issues of fact for the jury to determine. And I would ask that the court deny the motion for judgment of acquittal.
Thank you, sir. Court makes following findings for the record. Court has to consider the sufficiency of evidence to challenge. The court has to consider this evidence in light most favorable to the state of Tennessee. And the relevant question is whether or not any rational prior fact could have found essential elements of this indictment beyond a reasonable doubt. And the state is entitled to strongest, most legitimate inferences that can be drawn from this evidence. That's pursuant to Jackson versus Virginia, Jackson versus Virginia, citation by records 443 U.S., page 307, 1979, United States Supreme Court opinion, the state versus Davis, DABIS 354 Southwest 3rd, page 718, 2011 Tennessee Supreme Court opinion. Credibility of the witnesses, if the court will charge the jury and the jury for 6 days. The way to be given their testimony and the reconciliation of any conflicts in the proof are matters that are entrusted to the jury as a trial of fact in these cases, and that's pursuant to States versus Cabbage, CABDAGE, 571 Southwest 2nd, page 832, 1978, Tennessee Supreme Court opinion. Mr. Wilbourn indicated that he is in fact has pled guilty, has admitted, rather that he's in fact guilty of counts 2, 3, and 4 of the indictment. The jury still has to find that there is in fact a factual basis for those convictions before the jury can in fact find Mr. Wilbourn guilty of carjacking, employing a firearm in commission of carjacking, been a convicted felon in possession of a firearm. Those three charges are not being contested, but the jury again has to find and the state has presented factual proof and factual basis for the jury to return a verdict of guilty. And the court does find, addressing those even though have been raised in the motion for judgment of acquittal, that the state in fact has proven, and there's more than enough evidence for the jury, a rational trial fact to conclude that the defendant did in fact take a motor vehicle from the person in desperate either by abuse of force or intimidation, and that the defendant acted intentionally or knowingly. The court also finds more than enough evidence, absolutely undisputed, that the defendant employed a firearm, that the informant was doing commission of or attempt to commit carjacking, that the defendant acted intentionally, knowingly, or recklessly. So there's more than enough evidence for rational trial fact or any reasonable trial fact to conclude that the defendant did in fact employ a gun in the commission, a firearm in the commission of carjacking. There's also more than enough evidence that any rational trial fact did in fact conclude that the defendant had been convicted of felony offenses. It's stipulated that he does in fact have 2 prior felony convictions involving the use or attempted use of violence, that after he'd been ordered by a judge in federal court not to possess, not to carry, not to buy, not to own a firearm, that Mr. Wilbourn did in fact illegally possess a firearm, that acted intentionally, knowingly, or recklessly, and that those felony convictions out of federal court did in fact involve the use or attempted use of violence. The court does find that there's absolutely more than sufficient evidence for the jury to find Mr. Tremaine Wilbourn guilty of those offenses of carjacking, employing a firearm in the commission of carjacking, and then a convicted felon in possession of a firearm. Count 1, the state has to prove that the defendant unlawfully killed Sean Bolton. This is an unlawful killing. There's more than enough evidence for a jury to find that this killing was in fact unlawful. This is not a killing that was done in protection of the United States of America. This is not a killing that under Tennessee law there's any apparent justification for at all. The state also has to prove that the defendant acted intentionally, and a person acts intentionally when it's a person's conscious objective or desire to cause the death of the alleged victim. There is more than enough evidence for a jury to conclude that this was in fact an intentional killing. As the state has indicated, there are some 11 shots that were fired. 8 of these shots struck Officer Bolton. 1 of these shots were described as causing severe damage to his face, to his chin, that police officer and medical personnel were trying to hold Officer Bolton's face together in order to keep a sufficient airway open, in order to administer CPR, which turned out to be a futile attempt. And he fired multiple other shots based on a proof, while Officer Bolton lay prone on the ground. Proof from medical examiner's office is that some of those shots, 2 of those shots at least, would be consistent. But Officer Bolton lying face down on the ground when he struck multiple times by additional shots. Witnesses testified that Officer Bolton was in fact on the ground, that Mr. Wilbourn was backing up and fired multiple shots as he backed up from Officer Bolton. And the state has to prove that this was a premeditated killing. Premeditation is a factual-based issue that the jury rather has to make a determination in a case. Tennessee law, Court of Criminal Appeals, and Supreme Court have indicated that the nature of the injury is in fact relevant on the issue of premeditation. That's Cagle, C-A-G-L-E versus State 507 Southwest 2nd, page 121, 1973, Court of Criminal Appeals opinion. And what it refers to as Nichols or Bland factors rather, B-L-A-N-D, or Nichols, State versus Nichols, N-I-C-H-O-L-S, State versus Bland, citation for Nichols is 24, Southwest 2nd, page 297, 2000 Tennessee Supreme Court opinion. And State versus Bland, 958 Southwest 2nd, page 651, a 1997 Tennessee Supreme Court opinion. Those cases have indicated that certain circumstances may be indicative of premeditation. This court is not allowed to charge this to a jury. I believe the Supreme Court and the Court of Criminal Appeals need to revisit that. They've concluded that it may be a comment by the court on the evidence to charge those things that the law says, in fact, can be indicative of premeditation, but the state certainly has the right to argue those factors. And among those factors are a declaration of intent to kill, procurement of a weapon. In this case, there's no question that Mr. Wilbourn, in fact, had a weapon on him, that he unlawfully possessed a weapon after a federal judge ordered Mr. Wilbourn never to be in possession of a weapon. The testimony records that Mr. Wilbourn was, in fact, known to have carried a weapon, even though the witness did not see him with a weapon on this night in question, but did indicate that he had known Mr. Wilbourn to carry a firearm. The use of a deadly weapon upon an unarmed victim. Also, both is obviously armed because he is a police officer in the fulfillment of his duty. That approached a car, which was illegally parked, doing exactly what he should have done, because all those folks that testified indicated that when that car is parked in the wrong direction on the wrong side of the street, that is something that is very unusual for their neighborhood, and that is what originally caused those folks to focus on that, because Mr. Wilbourn was in a car parked illegally, in which a bug deal was in the process of being made, where the driver of the car had contacted a customer to serve or sell marijuana to that person. They're parked illegally on a street, and is 100% also both an obligation to do what he did, to approach that car, to conduct a brief investigatory detention, to lawfully detain those folks if he needed to. He was acting 100% within the scope of what he is charged to do. Did not, according to the proof, ever pull a weapon on Mr. Wilbourn, did not unholster his weapon, did not unsnap his weapon. Apparently there's never any effort made by Officer Bolden to use a gun against this defendant, even though Officer Bolden was carrying his service weapon. The proof is that he had 3 magazines that contained 12 rounds, 1 in the chamber, and 37 unfired cartridge cases were removed from that gun and from those magazines. So the proof on the record is that Officer Bolden never fired a shot at this location, never removed the safety restrictions, he never even allowed him to pull his gun at this location. So this is, in fact, a use of a deadly weapon against a person who may have been armed, but is absolutely not in any threatening position to this defendant. This killing is, in fact, particularly cruel. That is something else that the state can argue in this case. This officer was shot multiple times. Face was basically ripped off by a bullet, lying on the ground covering his face, and shot multiple times in his legs and upper thighs and other areas. And this is, in fact, a particularly cruel killing. The infliction of multiple wounds is something else that a jury could infer that this is, in fact, a premeditated act. As indicated earlier, Officer Bolden suffered at least 8 gunshot wounds to his body. The making of preparations before the killing for the purpose of concealing his crime. Mr. Wilbourn, according to the testimony after he shot this officer, jogged away, did not run away at a frantic pace, went a short distance, walked up to another person, pulled the gun on Desmond Ivory, demanded a car, told Ms. Ivory that I've just killed a cop, I need your car. And Ms. Ivory's testimony was Mr. Wilbourn was a little bit out of breath. Did not indicate that Mr. Wilbourn appeared to be traumatized, did not indicate that Mr. Wilbourn appeared to be under any distress, did not indicate that Mr. Wilbourn appeared to be under any panic, but simply that he was out of breath. The weapon that was used in this killing apparently has never been located. Mr. Wilbourn turned himself in after an intensive manhunt had been organized by local and federal law enforcement entities. He turned himself in with the gun that was used in the killing. Apparently has never been turned in, has never been located. And that's a fact that the jury can conclude as to whether or not this is, in fact, a premeditated act, and that the destruction of that weapon, or that weapon, in fact, has been secreted, because 3 years later, it is nowhere to be found. And the jury can also include or infer from calmness immediately after the killing that this was, in fact, a premeditated act. And the calmness after this killing was just a little sweaty, but not under any distress, when he approached another person immediately after Officer Bolden was shot and told another person, I need your car because I just killed a police officer. And there was nothing on the record that would indicate Mr. Wilbourn was under any distress or any heightened emotions, but yes, he was simply out of breath. Those are factors that the state can argue, that a jury can deduce that this is in fact a premeditated killing. As proved earlier, the state does not have to prove motive. According to State v. Jackson, J-A-C-K-S-O-N, 173 Southwest 3rd, page 401 of 2005, Tennessee Supreme Court opinion. The state does not have to prove motive in this case at all. But proof before the jurors that the defendant is in fact was on some form of release from federal courts at the time he committed this crime, was ordered by a judge not to possess a weapon. I believe the statements that have been made will not comment on that because I'll let the state comment on that. But that is a motive that could, in fact, a jury could infer as to a motive for this killing, that Mr. Wilbourn is in position with an illegal gun and does not want to go back to prison. The determination of the existence of premeditation is a fact question to be resolved by a jury. And again, I say versus Suttles, S-U-T-T-L-E-S, 30 Southwest 3rd, page 252. And those are just some of those things that a jury can consider when they make the determination as to whether or not this is in fact a premeditated killing. This court finds that based on the proof that is on the record, that there is absolutely more than enough evidence that any rational, reasonable trier of fact could in fact conclude, and probably at this point should conclude, that this is in fact a premeditated killing of a police officer who just happened to be doing his job, happened to be in the wrong place at the wrong time, when he came to a person that says, I'm not going back to prison, and fired multiple shots at Officer Bolton, 8 of those shots striking Officer Bolton's body. And this is a victim that was shot and brutally left in the driveway for no reason other than Officer Bolton was doing his job and checking a car that was illegally parked on a street. And for those reasons, the court will in fact deny the motion for judgment of acquittal and with no deception of the record, Mr. Gangula. Mr. Gangula, does Mr. Wilbourn, does he choose to present an additional proof?
May I board out?
Yes, sir. Mr. Wilbourn, come around, please, sir.
Stop at the front and raise your right hand, sir.
Mr. Wilbourn, stop right here on the Shelby County. Raise your right hand, please. Do you solemnly swear or affirm the testimony you give in this case with the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Mr. Wilbourn. Have a seat right here. Mr. Wilbourn, I already spoke. I said the testimony you give in this case is actually not a case that we're on right now. We're in a hearing. I know Mr. Gangula asked you about this on, I believe, Monday, if I'm not mistaken, as to whether or not you chose to testify. You told the court, you told Mr. Gangula that it's your intention to testify, and I told you at that point that that decision is not something that you could not change, that you could absolutely change that decision if you wanted to at any point prior to the jury coming in. And Mr. Gangula is telling the court, the jury, whether or not you choose to present any proof. If you're still of that position, Mr. Wilbourn, you may certainly not testify if you choose to do so. You may testify rather if you choose to do so. But if you tell me Judge Coffin had a change of mind, I've chosen not to testify, it's something that you can do also. You understand that? Mr. Gangula is not going to ask you anything about what he did or what happened at his time. He's going to simply ask you questions to see whether or not you have made or whether or not you will continue to make a decision to testify or not. Make sure you answer those questions directly and don't volunteer, don't say anything about what happened. You understand that? So, Mr. Gangula, you make a decision.
Thank you, Judge. Mr. Wilbourn, I've been your lawyer since August of 2017. Is that right?
Yes.
Ms. Paisley's been your lawyer as well.
Yes.
And Laurie Hall is also a lawyer, and she's been working on this case with us. Is that right?
Yes.
We talked to you about your testimony. Is that right?
Yes.
We met with you in the jail. We pretended to be the prosecutor. Is that right?
Yes.
We talked to you about what's good and what's bad.
Yes.
You understand that if you chose to testify, you could tell the jury your side of the case.
Yes.
And you understand that if you did that, you would tell the jury your side of the case, but there could be certain things that would come out that would be negative. You understand that?
Yes.
For example, your prior convictions for bank robbery and using a firearm in connection with bank robbery would come out. You understand that? Right. And you understand how you testify, we might open the door to potential gang involvement. You understand that? And I've told you that we might object when the state would cross-examine you, but if the court overruled the objection, the state would continue with that line of questioning. You understand that? You understand what's good about your testifying? You understand what's bad about your testimony? Are you under the influence of any drugs, alcohol, or any other medication?
No, antidepressant.
Does that affect your ability to see, hear, or think clearly?
No.
You understand your rights? And if you chose to remain silent, the court would instruct the jury that they couldn't hold that against you. You understand that? You understand your rights and your options. Do you wish to testify, or do you wish to remain silent?
I wish you remain silent.
Has anybody forced you into that decision?
No.
Are you doing that freely and voluntarily?
Yes.
No further questions, Your Honor.
Thank you. Mr. Wilbourn, you told me, I just spoke for the record, you told me on Wednesday that Judge Coffey, I intend to testify on this case. And I told you on Wednesday that you could change your mind if you want. Do you remember that? And is this your decision today to remain silent and not testify, sir?
Yes.
Has anybody thought of anything put in force, pressure, or made any threats to you in order for you to make that decision?
No.
Mr. Wilbourn, the other side, if you tell the court that Judge Coffey chooses not to testify, I will in fact tell the jury they cannot hold it against you in reason at all. They cannot draw any inferences. They cannot guess as to why you chose to remain silent. You understand that, sir?
Yes.
I will in fact tell the jury that. You understand that?
Yes.
And if you testify, I will tell them they have to look at your testimony just as they would anyone else. You understand that?
Yes.
Now, is this your final decision, sir? Because in a few minutes, you want to bring the jury back in and ask Mr. Ganguli if he has any additional proof. Mr. Ganguli, do you have any other proof that he intends to present?
No, sir.
And Mr. Ganguli is going to arrest Mr. Wilbourn, and at that point, you cannot take Judge Coffey, hold on a second, and change your mind like you want to testify. You understand that? Now, is this your final choice, sir?
It is.
Now, is this your decision?
Yes.
Because Mr. Wilbourn, sometimes people will sit in that chair and tell me, Judge Coffey, this is what I want to do. And then later, they'll tell me, Judge Coffey, I really want to testify, but my lawyers wouldn't let me. My lawyers tricked me. My lawyers made me not testify, and I'm upset at my lawyers. Now, is this your call, sir?
It is.
Do you have any questions, sir? Mr. Ganguli, any additional questions for Mr. Wilbourn?
No, Your Honor.
Thank you, Mr. Wilbourn. Step down from the witness, sir. And for the record, we had a discussion, Mr. Ganguli, with Mr. Wilbourn on Wednesday. I misspoke earlier Wednesday, October 31st, as to whether or not he wanted to testify. Mr. Wilbourn told the court, told Mr. Ganguli it had always been his intention to testify, and that he was, in fact, testifying in this case. And the court found on October 31st that Mr. Wilbourn had made an intelligent and informed decision to exercise his right to testify. And the court told Mr. Wilbourn that if he changed his mind, which he has an absolute constitutional right to do so, and said, Judge Coffey, after further review and after discussing the matter with my lawyers, or otherwise, I have decided to remain silent and to exercise my election not to testify. And this court told Mr. Wilbourn that was 100% his choice, and after trying further review, Mr. Wilbourn has now told the court, which was the moment MON versus State, 18 Southwest 3rd, page 152 of 1999 Tennessee Supreme Court opinion, that Mr. Wilbourn has elected to remain silent and not testify in this case. After finding Mr. Ganguli, this past in this hall, in fact, informed Mr. Wilbourn of the possible benefits, the advantages, the disadvantages, the possible good, the possible bad about testifying or not, including that if he testified, the jury would know specifically that he has felony convictions in federal court for armed bank robbery and another conviction, and that Mr. Wilbourn understands also that based on his testimony, that the possibility of gang involvement could, if it goes to something other than propensity, could become relevant. For instance, to show a motive, even though the state doesn't have to prove a motive, now some circumstances become relevant, and upon further review, the other federal case out of federal court was another felony case, federal case involving use of abuse of violence in federal court. That case been an alleged carrying a firearm during and in relation to a crime of violence. And Mr. Wilbourn, upon further review, has made it intelligent, has made it known, has made it voluntary, has made a personal decision to waive his rights to testify, and has chosen to remain silent. And I will, in fact, charge the jury that not voted against Mr. Wilbourn for any purposes, and no emphasis can be drawn from the fact that he's chosen to remain silent. And once we bring the jury back in, again, we will actually whether or not you have an additional proof, and will allow you to rest in front of the jury to state anticipate any other proof.
At this point, no, Your Honor.
And when we bring the jury in, what I intend to do is to charge this jury and then send them to lunch for a lunch break. And we'll allow the lawyers to start presenting closing arguments after the lunch break. What I intend to charge in this case, I need to change to reflect Mr. Wilbourn's decision not to testify at this time. We'll change that. And even though Mr. Wilbourn has indicated that he's pleading guilty to counts 2, 3, and 4, as required by law, Harbison, Harbison, I'm required to fully charge this jury. I will, in fact, charge the jury on count 1 of the charge offense, first-degree murder, and included offenses, murder, second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Will charge unauthorized use of motor vehicle, automobile, on count 2 of the indictment as included offense. Will charge included offense of possession of a firearm with the commission of a dangerous felony. And in count 4 will charge included offense of carrying a weapon with intent to go armed. Will charge on this case flight, as the court does feel the flight has been fairly raised by evidence when the proof is that the United States Marshal's Office in a multi-state jurisdiction spent parts of 2 or 3 days trying to locate Mr. Wilbourn at all known addresses, family members, and friends, and could not find him anywhere, but they were, I think the word was closing in on him, and turned himself in to the United States Marshal's Office, and will in fact charge flight on this case. We'll charge the long charge on identity. We'll charge the charge of fingerprint evidence that's circumstantial evidence, and there are no 2 people who have fingerprints exactly alike. And that charge of fingerprint, burden of proof, presumption of innocence, reasonable doubt, correct circumstantial evidence, impeachment of a witness, prior consistent statements, a long charge on witness credibility, a charge on Mr. Wilbourn's election not to testify. With a limited instruction in the convicted felon in possession of a firearm that's defined from proof that Mr. Wilbourn has been convicted of other crimes or crimes other than that for which he's on trial, that they can use proof of any prior felony conviction only as an element of being a convicted felon in possession of a firearm, and for no other purpose will in fact charge that limited instruction in the definition of convicted felon in possession of a firearm. We'll charge the jury on expert witnesses, 5 experts who have testified in this court. We'll also charge the jury on stipulation, and that is intended to be the court's charge in this case. Mr. Gang, will there be any objections or any requested other charges other than the things that the court has indicated?
No, Your Honor.
State of Tennessee, any objections to the proposed charge and recommendations for anything to be included?
No, Your Honor.
We'll make those changes. We'll reprint this charge. We'll bring the jury in, allow Mr. Gang and Mr. Wilbourn to rest. We will charge this jury, then we'll take a lunch break and start closing arguments after the lunch break. I'll call for recess and want to remain seated.
Court stands in recess.